This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Bolmer. And today I am excited to welcome two distinguished panelists, all returning guests to the show. First off, we have Dr. Jolie Brahms. She's the owner of Brams and Associates, a psychology practice and forensic psychology consulting firm with extensive experience in both criminal and civil matters, ranging from state and federal sentencing to educational litigation and beyond. Dr. Brahms holds a doctorate in clinical psychology from Michigan State. Dr. Brahms, welcome to the show.
Thank you.
Also joining us is Mr. Kevin Quinley, founder of Quinley Risk Associates, a risk management consultancy and expert witness service provider. Mr. Quinley holds numerous certifications in insurance management, adjustment, and underwriting, among others. He has a master's in government from William & Mary. Mr. Quinley, thank you so much for being on the show.
It's my pleasure. Thanks for the invite.
Of course, let's jump into it. So this series of panel discussions is on the topic of relationships. Now, every engagement is dependent not only upon expertise and experience, but it's a web of interactions between members of the trial team and the expert. And at the core is the relationship between witness and attorney. Mr. Quinley, how do you get off on the right foot with attorneys?
That's a very good question. And let me take a minute to quick hit on some ideas in no particular order. Number one, on the first call, be more on receive mode than send. Okay. You've got one mouth and two ears. We've all heard the nostrum. Number two, ask good questions. What do I mean by that? To assess your fit for the case, such as the universe of documents that need to be reviewed. That's very critical. Is there a scheduling order on the case? If so, what deadline dates for work product do those present? Is there a conflict check? Is the subject matter area in your expertise area? Number three, it's an audition, but I would say don't be too salesy. If they ask you about your bona fides, feel free to explore those. Be interested, be engaged with your energy up. Do your homework on the case if you can beforehand. What I mean is this: sometimes you'll get enough information on the case where in advance of that audition phone call, you can either Google the case, or if it's a federal case, go on Pacer and look up information about the case. That can quickly, doing a little bit of homework, orient you to the contours of the case, the general thrust of the case, and enable you to ask smart questions. Get all deadlines clear up front and don't overcommit. I think that's important. Be clear that you are not an opinion for hire. I always try to make clear that I won't know what my opinions will be until and unless I review the materials. I don't guarantee a favorable opinion, but if I can't give one, I will pick up the phone, not write to you, pick up the phone and explain it to you. And set the ground rules in a follow-up engagement, in terms of billing, the materials that you need, and be willing to sleep on it if it's not super time sensitive. There's sometimes when you learn about a case, I don't want to be pressured into making a hasty decision, and I will buy myself some time, just but like one day, and say, look, let me process what you've told me and look at the entire continuum of other obligations I have currently with other cases, professional meetings, personal vacation, and get back to you. So I think being willing to say no thanks and maybe recommend somebody else if you honestly self-search and don't have the bandwidth. Those are all some quick stream of consciousness tips on how to get off on the right foot with counsel.
Dr. Brahms, same question. How do you like to get off on the right foot with engaging attorney?
I think that getting off on the right foot is starting from the very beginning, and that means returning phone calls. I get many, many attorneys call me and they say, you were highly recommended, but we got two other people, and you're the only person who not only returned our phone call, but most importantly, returned our phone call with some interest and knowledge on the other end. Now, I'm very fortunate. I have a practice director. And if you have a busy forensic practice, I strongly recommend you get someone to work up front, because as the busier you get, the more calls you're going to have at all times of the day and night, the more demands, the more reports to proof. But what really has promoted my business, and I don't mean that in a sales way, I mean that in a professional manner, is just not my work. And again, I'm sure Mr. Quinley will agree with me. You have to be perfect in what you do. You have to be very thorough. It's what she does at the front end. She knows my business. She really understands civil and criminal litigation. And when these people call, she basically vets people. And she also talks to them about who I am and what we can do. And she generates not sales, but enthusiasm. She also sets, as Mr. Quinley states, limits and boundaries. What are the expectations? What funding is available? All of those things. And she provides these people also expert with other expert consultations and testimony that I've given. So that up front shows your practice to be professional, and it creates a whole ambiance for the rest of the consultation. That you are not somebody who just was found off the street, that you're a knowledgeable person, that the people who work with you will get things done for your case, for your client. So that is, to me, is the most important first step.
Let's talk a little bit about some of the intangibles that go along with those initial phone calls. You had said, Mr. Quinley, not to be too salesy. Can you go into that a little bit? How does somebody have a demeanor that shows professionalism, but isn't necessarily trying to pitch the attorney?
It's a good fine line to walk, a tightrope to walk. You want to be confident, but I think less promotional and more descriptive of what you bring to the table. If applicable, when I talk to prospective attorneys and we start covering that terrain, obviously I'll volunteer to send them after the call a copy of my current CV, and then I've got a brief one-page professional biography that gives them the Reader's Digest version. But just tell them, I've been in this area for 47 years. I've written 10 books on such and such a topic. I have been a contributing editor to some of the training textbooks used by a national organization for training people in insurance claims. I've given 300 presentations. I've been engaged in 160 cases. I've testified in 50 plus depositions and 15 trials. So just to give them, that's factual, it ain't bragging if it's true, but to be factual and to let them know, but this is not a hard sell. And I'll say that it's not a hard sell. I'm not selling, you're buying. And, I'd love to work with you if the stars align. We'll get to that in terms of bandwidth and deadlines and size of the universe of documents. But I think that's where you just factually, if prompted, rather than being, but spend most of that initial time listening and then give them an honest reaction as to whether you think you can be a resource or not, which is not exactly the same thing as warranting a favorable opinion. I always caveat my reactions by saying, based on what you've told me, I think there's some traction there where I might be able to help as a resource. But even if you end up bailing on the case because you don't think you can support them, or there are weaknesses in the case, you're providing a service for that. So that's a long-winded answer as to how to be more informational than promotional and augment that with a follow-up. And I love the point that Dr. Brams made, that you follow up as you promised to with your CV and with a fee schedule, and if they ask, and a professional biography.
Dr. Brahms, any tips on demeanor?
Yes. The way that I look at everything I do in terms of the salesy issue, as Mr. Quinley talked about, it's authentic marketing. It is who you are over the course of time. Now, Mr. Quinley states he's been doing this for 47 years. I've been doing it for 42 years. I don't think we're in a competition for age or looks. But for example, I had an attorney call me who I did know from before. Very nice firm, medium-sized firm. I do a lot of several personal injury evaluations for them. And they were stating how this woman was in an accident, and that she has significant emotional trauma from that. Given the nature of the accident, that's understandable. But he also mentioned that she was already on Social Security disability, and he said that that was for depression. Now, I know, because I've done this for more than 4 decades, is it's very difficult to get SSI, and she had to have another diagnosis than depression. And thus, we need to look into her pre-morbid functioning more than just an assumption. There's much more to it than meets the eye. So the fact, that's a very simple example, but you have to use your years of knowledge to basically be the crystal ball. I have people call me up about cases, and I tell them what to do, and they're like, how did you know to do that? Now, do I tell them what to do because it's going to get me involved? Sometimes. Many times, I think this is extremely important, especially if you have a long career ahead of you, is you give information that is helpful without the expectation of getting that case. You become a colleague, and you make it very clear in that conversation, I've given you this information about, I do a lot of death penalty work, a lot of very high profile criminal cases, and I realize that not everything that anyone has to offer will cover all bases. So what I say is, even if you don't hire me for this, consider me a friend and colleague. We always talk personally. Where did you go to law school? Who do you know? Have a real personal conversation. And when they know that this is not a pressured situation, because in truth, although I want to work with people, I don't need the work. But it's always important to have that, but that's not the reason for the call. And what I find is that years later, it could be 8 months later, it could be 3 years later, I will get a call back either from them or from someone they know, because I acted as a colleague and not someone who's there just to provide a service. And that is what the attorney-expert relationship should be. It should be colleagues. We have boundaries, we have demands. As Mr. Quinley states, we don't get paid for an opinion, we get paid for our time and expertise. As a psychologist, I put that in my releases all the time, that we are paid for our time and expertise and not to provide an opinion. And I know sometime I hope we'll talk about bad opinions, because there's always bad facts and bad opinions, and there's ways to handle those that actually need to be very proactive. So again, it is a relationship. And if you have an attorney who calls you and you don't feel you can establish that relationship, it never ends up good. Very briefly, and there was an attorney that called me, I won't give any more details, who was perfectly nice on the phone. She was perfectly polite and appropriate, but there was no way to establish any excitement about the case with her, no way to establish a connection. And I did take that case, and the case is terminated. It's been pled out, but it was a miserable experience, I think, for both of us, because I was looking for a collegial connection and some excitement about the case, and she was very factual and bland. And I don't think it was a good fit. I don't think it was a good fit, and I don't think it was from the beginning. Not that we did not help the client, because I believe we did help the client, but I believe in some ways we could have been more effective and just better had there been a mutual meeting of the minds.
That's an excellent segue to red flags. What are the sorts of things you've mentioned a few, Dr. Brahms, regarding a lack of excitement, somebody who doesn't maybe appear totally invested in the case? What are some of the other red flags that you look for during initial calls and maybe your first meetings together before you've accepted the engagement or when the engagement has just begun?
I think that there are many red flags that you have to be experienced and willing, the other word is willing, to accept, because many people really want consultative work and they're willing to overlook those red flags. One of them is a lack of curiosity when you talk to them about possible hypotheses and possible ways that a case can go. There are people who look at things very simply. And so I was contacted about 2 months ago by a personal injury attorney who did not work for a personal injury firm. They worked for a corporate litigation firm. And they were asked to do this personal injury case by a client who spent, I don't know how much, probably $1 million a month easily, as they were the firm that dealt with this client's gigantic international business. And I believe they were talked into dealing with this personal injury matter. I got a 1-sentence email from the attorney who says, what do you know about X, Y, or Z? If you're interested, call me. That was it. No Dr. Brahms, no thank you, nothing. We contact him by email, and he says, well, all I need is to do one of those psychological tests and give me a diagnosis. Well, I wrote him back and I said, a diagnosis means nothing in terms of personal injury. You have to look at functionality, history. There's a vast amount. If you want to really represent this person appropriately, it's more than a diagnosis. And he wrote me back a unpleasant letter, an unpleasant email stating that he had found 3 other experts who knew what they were doing, and I did not know what I was doing. Now, the red flag was number one, that first email. The red flag was you don't speak to anyone. You don't speak to your little brother like that if he just bothers you, okay? You don't send anyone an email like that. My second email was as cursed as the first one. You don't work with someone who's convinced that all you want is a 10-minute evaluation for a diagnosis. And the other issue was the fact that they were a corporate litigation firm. What are they doing personal injury for? Now, what I do is that Mr. Quinley does is I Google as I talk, and my practice director Googles as she talks. We Google the firm. She'll tell me that she's the one who told me initially that they were a corporate litigation firm. So it did not work out, but those are red flags. Now, briefly, had I done this case and I had gone beyond, first of all, legally, I have to go way beyond a diagnosis. Professionally, I have to go way beyond a diagnosis. If I just listened to what he said for the money, I would be hurting my career, my reputation, and I would not be helping that claimant.
Mr. Quinley, same question. What are some of the red flags that you look for in initial conversations for a new engagement?
Well, I have my own pet list in no particular order. Number one would be unrealistic deadlines and timelines. I'm talking about last minute, hair on fire, 11th hour engagements where they've known about the deadline for months and now they've delegated to some legal assistant or paralegal, find me somebody who can fog a mirror. I'm sorry, I'm not McDonald's. Would you like fries with that? We are professionals. I don't put it that way to them. But inwardly, my internal dialogue is WTF. What have you been, which is legal abbreviation. You can fill in the blanks mentally. What have you been doing on this case for so long? Do I want to get into that environment? Okay, enough said. Number two, comments like this. I'm shopping around for an expert. Okay. I'm not in a gasoline price war. This is not a commodity environment. What I try to offer is a bespoke, customized work product. So if I get a sense that it's a commodity or my last expert bailed on me, that's a red flag. Now, it could be perfectly legitimate reasons. I've had them, illness, death, whatever. But if I need to know the context of why that prior expert is no longer on the case. Another comment, I will write the report or disclosure for you. You just need to sign off on it. Okay, I'm sorry, I don't do business that way. I'm not going to, as Dr. Brahms said, it's my name and reputation on the line. So if they say, I'm going to make things easy for you, I'm going to write the report. No. When the red light goes on and I'm sworn in to testify or walk into that courtroom, the longest walking journey in the world from outside with the bailiff saying, it's your time, Mr. Quinley, I'm the one who's got to defend that. So if they say, I will write it for you, to me, that's a red flag. Or I need a report and expert saying such and such. Okay, again, they want to channel my opinions into a prefab mold. No, doesn't work that way. I'm going to reach my own independent conclusions. Or they need another expert in an adjacent subject matter discipline, but they want me to go beyond my swim lane, beyond the bounds of my professional expertise, and basically get 2 experts for the price of 1. For example, I work in insurance claims processes. A lot of these cases also involve insurance coverage questions and interpretations. That's a somewhat adjacent but separate field. I consider myself an expert in one, but not the other. But sometimes they are interrelated and they want to push the boundaries of where I'm willing to go. Tire kickers, which appear to be focused inordinately on costs and budgets and constraints. I understand the need for cost consciousness, but I don't want to feel like I'm micromanaged or have to say, Mother, may I, before I do anything on a case. How much will it cost? How long will it take? It'll take however long it takes. It will cost whatever it does cost. My focus is on doing a thorough job, not on wondering, gosh, am I going to get a bill complaint here? A couple final thoughts. A firm that I've had at one or two firms say, we don't pay retainers. Have a great day. And then they've come back to me after trying to find an expert who will work for them without a retainer and said, yeah, we'll pay the retainer. I'll prep you for the deposition on the morning of. I'll meet you
No.
in that morning. No, I don't work like that. I tend to be OCDC, and there are issues that I want hashed out pre-deposition or pre-trial with counsel. None of this stuff. I've made that mistake before at the beginning of my expert witness journey. The morning of, that doesn't work. And finally, I've had this happen a couple of times where retaining counsel says, trial is a month away. Do not spend any time prepping. No, it doesn't work that way. I'm going to spend time prepping because I'm the one who's going to be called up there on the witness stand. And I know it could be settled, it could be continued, whatever, but I'm going to prepare and we'll deal with the billing issue later. But to me, I've embedded in my engagement letter various grounds for withdrawal from the case. And one is unreasonable constraints on my ability to perform my job. And I consider that an example. So that's just sort of a little shop of horrors tour of what I consider personally red flags.
Some of the guests that I've interviewed have mentioned that one strategy or tactic that attorneys will sometimes use is to choose a higher profile expert, such as yourselves, and just having that name attached to the case can drive the case towards a settlement. Has that happened to either of you? And if so, do you put anything in your contract to make sure that you get paid in case of a settlement?
I can answer that one. Yes, it does happen, both in a good way and a bad way. And it depends what the lawyer understands. I have been used in cases, especially criminal defense, as a checkbox. They have to hire a forensic psychologist. They do. They don't really understand what you do or what you're doing. I can talk about this because it's on the news. I had a case where the attorneys, in my view, did not do what they were supposed to do. And they used me as a checkbox and did not give me the resources I needed, did not give me the time that I needed. I don't want to be a checkbox, and no one should do that, both for the client as well as for yourself. But I will have to laugh and state that someone as experienced as myself or Mr. Quinley, hiring someone like this sometimes does move a case along. And I've had cases where I'm like, oh, great, I get to work with these people. And this has happened maybe 3-4 times in my career. And the minute they see me on their side, opposing counsel just settles. So and as far as getting paid, I probably spent, at that point, 10 hours looking at the records, and I bill them for what's fair. So yes, I believe that having someone, I've been on both sides of cases, and sometimes I testified against people that are very, very, I'm not going to put this, in your face type of people, nationally known people. And yes, it does put fear into the other side.
I would have to confess infrequently. I have had a few cases where retaining counsel well into the case with some key deadline approaching has indicated to me that my presence on his side helped spur case resolution. But as much as I would like to think that my footprint is such that the sheer mention of my name is an intimidating factor to the opposition, I have to candidly say, I don't know whether it's flattery. I would discount that because being realistic. But I've had feedback in maybe 2 cases out of 160 where I felt that happened. I'd love to see that happen, but I don't have the hubris of buying into that and saying that for that reason it would scare off or have a material impact on case resolution or progress.
But Mr. Quinley, I believe that the quality of the work that an expert does push towards settlement. I believe that if you write an articulate report, if you do an articulate deposition, it clearly pushes towards settlement. And absolutely. And obviously, when you and I do these things, you only do it, from my perspective, I only think about the other side, whether it's a plaintiff or defense attorney, depending who I'm been retained by, or mainly in criminal cases, a prosecutor. You're always thinking 10 steps ahead. You write honestly, you perform honestly, but the best expert in the world thinks ahead. They don't think just about what they have to say, they think about questions that people are going to ask.
I totally agree. And then the decision turns on the quality of your work product rather than my brand name, however exalted I would like to think it is.
Excellent points. So we've accepted our engagement. We're continuing on. It's going to be a positive engagement. What makes for a positive relationship during the engagement once we have got beyond the initial phone calls and we're right in the thick of it?
Well, someone told me the other day, Noah, that the best thing would be alcohol. That alcohol would definitely solidify our relationship. But again, I've known him for about 15 years, and I think our relationship's already solidified. But when I knew this podcast was coming up, I thought that would be something interesting to share. But I think that what he meant was, besides the fact that drinking is something he likes to do, I think it means that moving along means that we have to have consultations, that you can't just have an expert do their thing and leave them alone. There has to be communication. And the problem that we run into is when there's no communication. You're not updated, there's no hypotheses tested. You have got to have a continuing dialogue with your expert as this case moves on.
And I love the focus on relationships because I think that is great. And I think that is aspirational. However, I will also say that in this work, you find a whole range of quirky personalities. And sometimes retaining counsel, they ain't looking for a relationship. It's more transactional. And so I try to be open to either style. I would love a relationship to start occupying that trusted advisor role that I think Dr. Brahms has described. But not every attorney wants that. And I've had some quirky, and among experts, you've got quirky personalities who, might have the personality of a dead duck, but they're still, very authoritative. But in terms of, I'll be briefer here in terms of a recipe for positive interactions or relationships. Number one is to set clear expectations. And that goes back to the engagement letter with the appropriate disclaimers about what you will and cannot deliver, the boundaries of your subject matter expertise, no warranty of a favorable opinion or a case outcome. Number two, over communicate. I totally agree with Dr. Brahms there to over communicate with counsel, err on the side of over communicating, because sometimes I have found out by accident that my deposition is set for 20 some days ahead, where the case had been set for trial. My God, if I hadn't checked in, how would I have found out? So you be proactive about that. Number three, if you've got a jumbo bill, if you've got a really big bill coming, get out in advance of that and communicate that in advance to the client that, hey, this month's bill, this quarter's bill is going to be higher than normal, and here are the context factors for it. Big supplemental document production, some additional depositions. The scope of the engagement has increased, but don't never surprise the client with the size of the bill. Let them know beforehand, prepare them, and I think it's no guarantee, but it helps grease the skids on that. And finally, this echoes an earlier point. Be willing to pull the ripcord early if you cannot help. If you get into whatever the counsel tells me on that first call, I take with a grain of salt, not because I assume they are liars, but as I say, the flattest pancake has two sides. And when retaining counsel contacts you, they're advocates, they're paid advocates, and they're giving you one side of the case. And I usually find out that it's not black and white. There's shades of gray as you dig into the case materials. And if it's so gray that you don't think you can help, then I think be willing at an early point to make that phone call and have that awkward but necessary conversation as to why I don't think I can help you. I'm not saying you don't have a case. And you might be able to find another expert who disagrees with me, who's willing to say it. But in fairness to you and in the interest of transparency, I don't think I can help your case. Sometimes it's in a gray period, or a gray phase, where I will say, look, I've analyzed how this insurance claim was handled. There's some problems here. Some aspects I can defend, others I can't. I'm going to have to give ground where I must, so I don't compromise my own credibility and with an eye toward future cases and consistency. But there are other aspects of the case that I can defend. If you're okay with that, then let's proceed on that basis with those caveats. And I've had counsel say, you're right, I agree. Sometimes it's the client who wants to fight it, but they understand. And so it may not be that you're all in or you're all out, but you say, so, like every case has strengths and weaknesses. And some of those weaknesses, I think you have to flag for counsel and say, look, I'm not gonna joust at windmills on some of these points, but I think it will boost my credibility on those points I can defend.
Yeah, along those lines, as you've both stated, an expert's duty is to the neutral truth, and you put that in your engagement letter. Sometimes I am not going to give you an opinion other than what my opinion is, regardless of what you want my opinion to be. You had just stated, some of the methods that you use to give bad news to your engaging attorney and to the end client. Dr. Brahms, how do you go about communicating bad news to your engaging attorney?
Well, I'll be honest with you. I've had a couple cases in the many years I've done this that it truly is bad news. There's absolutely nothing that myself or any other expert can do to help a defendant. That's in criminal cases. There's nothing that anyone can do in terms of sentencing. There's nothing diagnostically. There's nothing myself or do I believe anyone else can do. However, bad news is not always bad news. There's cases that I have where I do not believe that my testimony is going to be helpful. I believe that my testimony would be hurtful because we would be picking at straws. We would be taking little minute details and making them into big things. And that is going to make a jury not trust the attorneys, not trust me. However, there are things that I advise and ask to be a consultant on a case to help that attorney deal with direct examination or cross-examination. I can give you a very brief example. As you well know, there are many, many allegations of child sexual abuse in this country. Some of them absolutely seem valid. Some of them come from situations where there's questionable reasons for the outcry. And many times these children are being interviewed in small counties where the interviewing techniques can be very coercive, very contaminating. And there's obviously been, if anyone knows this, 4 decades of research on this issue. I was early in my career, helped develop some of these techniques, some of these interview techniques. But very briefly, if I believe that there's very little information for me to testify about, but I believe that this county has not hired the right person or has the right protocols, and I think there are things that can help the attorneys bring that into the attention of the court, the jury, or whoever. I can help them look at the family dynamics. There are many, many ways that I can help besides testimony. Not everything that we do is testimony. And there are bad facts. Most of the cases I have bad facts. The people I work with are not very functional people. There's always bad facts. So how do you deal with the fact that a defendant had a prior criminal history? How do you deal with the fact that in elementary school he broke a desk? What do you talk about? Well, from my perspective, I would talk about the whys. We don't hide facts, we deal with them. So our job is delivering bad news, but yet with good news with it, if at all possible, with some other way to be of assistance to that team or that attorney, if possible. But yes, it is our job to deliver bad news. And many times I'll hear about a situation and I will warn people up front. I think this might be more bad news than good news, but do not hide anything from me, because you hide something from me, and that's a huge issue, is hiding information. Because if you're on cross and you don't have everything given to you, you might as well not testify. You might as well just lose the case for the attorney. And attorneys like to hide things, and I am very strident about that. I need to hear what is happening.
On occasion, it'll be one expert and one attorney, and that's pretty straightforward. But very often, there's large trial teams with a lot of moving parts. There may be multiple experts from different areas. There may be some experts in the same area. There may be paralegals. There may be assistants and a lot of different people. To what extent do expert witnesses interact with the rest of the trial team? And do you prefer to try and work directly with the engaging attorney, or is it okay for you to interface through an intermediary like a paralegal or an assistant?
I feel comfortable with any of them, and I think an effective expert witness needs to set aside job titles and treat anyone within that law firm structure as the client. Now, obviously, I'd prefer to, it depends on the context. Substantive issues on the case, I want to speak with the attorney, whether it's a partner or associate on the case. If it's logistical issues with regard to specific documents I need clarification on or need additional documents, clarification on timelines, I think it's important to contextualize the kind of information. But I would say even when you're dealing with the receptionist, whoever answers the phone, I try to be unfailingly respectful and polite and essentially build good karma with every strata of the organization and hierarchy of that law firm, so that it, as opposed to an elitist view that I only deal with the partner, I only deal with the attorney, because if you're curt, if you're brusque, if you take out your frustration on one of the lower, let's say the less exalted members of that hierarchy, I don't want them, I want those frontline people, whether it's a paralegal, a legal assistant, or receptionist, to say, Mr. Quinley is a pleasure to work with. I always thank them, always tell them have a nice day. It sounds trite, but I just think it helps in building this relationship and having constituencies with multiple constituencies within the firm saying, yeah, he's easy to do business with.
That's an excellent point, and I just like to elaborate on that. I believe that experts need to understand how attorneys work, and they have to understand how we work. Obviously, when there's the initial phone call, I need to set something up via Zoom with the attorney. I'm not going to hear about a case totally from a paralegal. That would not be appropriate because those mutual decisions and relationships cannot be established. But they have to understand how we work. Okay, I understand that attorneys are very busy. I know the people I work with, and I understand the roles of various people in those firms. And like you, I'm nice, and all those things are important. But to understand where you can get information from, who has to get authority to do certain things is important. But what I find is many times they do not understand what we do. They do not understand the amount of work it takes to do what we do. I've had I'm not complaining. I'm very, very grateful to be doing well and be respected. But I probably have gotten up at 5 o'clock in the morning for the last 2 months and desperately trying to get things done. I have a case on Friday. It might only be a 50-slide PowerPoint, but every one of those took tremendous research into the discovery, consideration about how to make that, how to present it, how to organize it, what should not be in there. These are huge tasks. This is not getting up and taking 5 minutes to put together a little funny slide deck. In order to really be ready to testify, to understand all of the timelines and the issues and the people, there's a tremendous amount that goes into this. And I think attorneys need to know what it's like to live our lives as well and how we conduct our business. And so a lot of young forensic people get into this field and they really do not understand what attorneys do. And therefore, unlike Mr. Quinley, they don't have a lot of respect for people. It's like, get me to the partner. I don't want to talk to you. Whereas you can gather a lot of not only good points, but information and assistance from other people in that firm. So it's a mutual street, knowing what we do and we have to know what they do.
And I think that underscores a crucial point of being proactive in one's communication with counsel. In other words, do not assume that they have top of mind awareness of your need for information as to the progress and status of the case, whether it's a rebuttal report deadline, oh, by the way, or a deposition date, or a trial date, or a Daubert type of exclusionary motion that, oh, by the way, has been filed against you. Take the bull by the horns. Do not assume that they will inform you timely. A lot of them do, but don't assume it. Put it on a regular follow-up diary, just a friendly check-in. Has anything new that newsworthy on this case happening that I should be aware of? Do you envision any deadlines over the next 60 days that have implications for my role in the case, and so on and so forth? That kind of regular follow-up, it's no guarantee, but I see it as a safeguard again, because they don't understand how we work and probably never will. That's where you get a bunch of experts together, and as therapy, they share stories about these types of weird situations, but there are some ways to try to prevent them and preempt them.
On the flip side, what else can attorneys be doing to be better attorneys vis-a-vis their experts?
I would say be intellectually curious and educate yourself. I know that I can never do what Mr. Quinley does. I'm not going to be a risk assessment person. He's not going to do what I do. But if we were both attorneys working on a case, I know that I would want to find out as much as possible about what I need from an expert and what an expert might do and how to have a conversation with that person. And I think from what I do, some of the things are commonality. So if I talk about parenting styles, every attorney should have read, Parenting Magazine, or they should have listened to the Oprah Show or whatever, and heard about these things. But what I find is that the way to be an excellent expert in what I do is to read the New York Times every day, if possible, to listen and to learn about the world. In the job I have, I'm very fortunate that I travel everywhere and I go to people's homes and I sit in their trailers and their apartments and at McDonald's, and I've heard stories, and I've had the blessing to be able to really understand the world around me. It's hard to just be an expert and know one field and that's all you know. I think that you have to see things in a much bigger picture. And I think attorneys, to be good attorneys, need to have a better understanding of more than just what they do every day. Cases are complicated, people are complicated, and you do best when you are a worldly person.
And because it's complicated, be proactive. And again, I hate to sound like a broken record. Do not wait to the last minute. Do not treat your expert witnesses like the fast food drive-through at McDonald's. We are professionals. We're not the expert equivalent of an emergency room. And so be proactive. Get your experts lined up early. Be transparent. Be thorough. Another mundane thing is pay your freaking bills on time. I mean, I have had, virtually all of my cases involve situations where somebody is claiming that the insurance company did not follow through on what it promised to do. Okay. And I'll be on, let's say, the insurance carrier side of that. And my engagement letter clearly spells out the timeline for payment of my invoices. Okay. And where they just ignore that. And among other things, I appeal to their sense of fairness. Look, I'm trying to make a case that XYZ insurance company is a company that stands by its promises. And here they're delaying and foot dragging and not living up to the very commitment that they signed on for at the beginning. Now, come on, help me out here. And so it marginalizes, it sends a message to the experts sometimes, you really don't matter. We just want the work product, we want the opinion, we want the access, but pay you for your services mañana. The lawyer is getting a paycheck or a draw and or a bonus. I'm not in a situation anymore where I have a paycheck. And I'm fortunate, like Dr. Brahms, that I'm very busy. But still, I think that pay your bills on time, be early, be transparent, be thorough, be communicative with the expert.
Without naming names, are there attorneys that you would not work with again? And if so, how do you handle when their firm contacts you?
That's a very difficult question, but I think it's an important question. You mentioned the name firm. We could start off talking about individual attorneys.
Sure.
Okay. And I think that you could either be very gentle and factual. It will not go over well. Nothing you say is going to go over well. You could say something like, we worked on this case 3 years ago. I'll be honest with you, as Mr. Quinley was saying, it said it took 2 years to get paid. I had to write the judge to get paid. I was a little concerned that you were so busy you didn't really have time to discuss the case. I don't think it went well. And I really have other priorities right now. I can try to refer you to somebody else. That's what I can do. And they're not going to like you. But you also do not have to be, forced into again in a situation that you don't want to work in. And that happens to me. I work with a lot of small town Ohio, especially in Ohio attorneys. Not that they're bad people, but they are just not up to par in terms of filling not just the billing, although they don't always file that, but just in terms of what Mr. Quinley's saying, staying in touch, having interest in the case, communicating, and it's a lot of work for nothing. As someone I know would say, it's too much sugar for a dime. It's just too much. But no, are they not going to like you? And you have to say to yourself, does it matter? Do I really need this aggravation? And I have other things to spend my time on.
And that, I think, is a key point in terms of where you are in the life cycle of your career
Yes.
as an expert. Frankly,
Yes.
you're starting out and trying to get traction, trying to get business and trying to get cases. I have taken those 11th hour hair on fire assignments. I have taken cases with attorneys with whom I didn't feel that simpatico.
All of us have.
And so you hopefully you develop some positive snowball traction with your practice and word of mouth, and you have a nice flow of cases, and you have the luxury of saying thanks, but no thanks. To your original question, are there certain attorneys that you don't want to work with again? Absolutely, yes. Just like there are probably some attorneys who would not want to work with me again. Right. I understand that. So I think the situation that you frame calls for the utmost diplomacy and delicacy. And I'm not sure how much detail that the expert needs to get into. I think it is certainly, you thank them for thinking of you, okay? But you can plead workload.
That's true.
Bandwidth constraints. There are a whole lot of ways to diplomatically say no. You can offer them a copy of an article. You can recommend to them another expert in your field, and be a resource that way. But I would hesitate to get into the fact that they were foot dragging on bills, they were difficult to work, all of which may be true. But I think I would soft pedal that, not go there, and have some, very plausible, legitimate other reason. And
yes.
You don't have the bandwidth because it happens to be that particular attorney. But
then Mr. Quinley, they tell you they're going to get continuance because they desperately want you. So they'll get a continuance. I hear that all the time. They'll get a continuance. But I want to talk about young forensic experts in whatever field. You're right. There is a real goal that people have to have, and that is to do whatever is necessary to get experience. To have that experience, not just on your resume, but in your head, that you have done case after case, and even if they're small cases, or even if you don't like the attorney, that you have that. But what some experts get into, which is to basically be, as one of my colleagues states, a bottom feeder. A lot of people are stuck in their careers to always work with small cases, attorneys who aren't well known, never getting a lot of word of mouth because of where they do it. And it really does take, we talked about marketing and sales, as Mr. Quinley stated way at the beginning of this podcast. There is a point in time that you have to sell yourself if you're young, and it has to be done in a way of authenticity of who you really are. I would like to tell you that nowadays, nobody looks at a newsletter. Nobody looks at an email. The only way that you are going to get referrals is by word of mouth. Maybe if you teach somewhere, I don't think there's anything wrong with being assertive and aggressive. And if there's a local organization of attorneys, whether it's a local, your city bar group, they meet for lunch every month or whatever it is, if at the beginning of your career, be willing to do that. You meet a lot of people, you learn a lot, you develop poise and expertise. But it is difficult, and you have to make sure that over your career that you're moving up and you're not moving sideways.
And I think the way to get those word of mouth referrals is essentially doing a kick-ass job.
That's right.
On those initial and subsequent cases. What do I mean by that? I mean that you're analytically thorough, in impartial in looking at the case, that you meet every deadline without being a drama king or queen, that you provide as immaculate a written work product,
Yes.
bulletproofed and vetted as you can, if it's a Rule 26 report or a disclosure in state court, that you are prepared or over prepared for that deposition. And in the unlikely event, because I say 1 out of 10 of my cases actually go to trial, that you likewise for trial. So it's such a kick-ass job that when that case is over, whether they prevail or not, whether they settle the case or not, they say to themselves and to colleagues, this guy or this lady is the real deal. And so you don't do that by handing out cards at trade
No.
conferences, although there's a role for that. But your work product, your timeliness, your ease of doing business with, the quality of your analysis, the thoroughness of your report, your rapport, your soft skills, your testimonial preparation and performance within those highly stylized forums. I call it a performance art. I think giving testimony, both
Yes.
in deposition and trial, are very related but not quite identical performance arts. And the more you do it, hopefully, the more comfortable you become and the better you become. Always have a growth mindset of improving upon the last. I look at reports and testimony from that I gave 10 years ago. It's cringeworthy now. I look back on it because at the time that was, relatively green. That's not to say I'm at some exalted stage right now. The point is, it's an iterative process. You're learning and you're trying to improve each time.
You're very articulate in what you say, and I agree with everything that you share. And they're words, you have to practice them, but you practice them by understanding the absolute importance of what we're doing in this field. And what we're doing is we're keeping alive our judicial system, which is what makes us a democracy. It's what makes us a civilized society. And the judicial system is the basis of everything. And for me, it's the basis of someone's life. For you, maybe Mr. Quinley, it's more financial. What you're doing has to do with more keeping business appropriate and people getting the right, whether it's a business or a person getting the right outcome. Whatever it is, we have a real responsibility to do what we do. And a forensic expert has to understand that. I think that's part of as we mentor our colleagues, and we're at the point that we do mentor, I think that's important. But as a personal story, and about, I think what this gentleman's sharing is that about 6 months ago, I got a call from an attorney, and I barely recognized his name. I kind of knew who he was. He was local, and he had been on the other side of a case that I was on. And once he told me that, I realized who he was. And I said, well, like, why are you calling me? He says, because they lost big time. He says, because you're the best person I've ever known. He goes, I want to hire you for my case on this side. So he was able to get over, in quotes, losing, knowing that I had the qualifications and the ability to make the other side be more successful.
And that's the ultimate compliment, I would say.
Yes.
When you have an opposing counsel on a former case reaches out to you
Yes.
because of how impressed he or she was with your performance, that is the ultimate compliment, I think.
It is. It is. I certainly took it that way. And so I think what we're saying here is that being an expert witness is not just an easy job. That is a job that has enormous responsibility, and attorneys have the obligation to choose and work with the right person. And we as experts have an obligation that's the same, is to choose and work with the right people and to do justice where it's served, and to be thorough and honest and independent. And those are difficult things to do because we're all faced with money and wanting to win and pressures. But the more that we resist those, I believe the better it is for everybody.
That's a great articulation of the big picture role, I think, of expert witnesses. I don't think I've ever heard it expressed better. And that, we do have a positive role and not get hung up on winning or losing. I've written about this. I've talked about this with fellow experts. I've been on the losing side. It's always more fun to be on the winning team.
Of course.
But I have had cases where I tried to do a kick-ass job and they still lost, and I've had other cases. So I try not to get hung up on the end result. I'm focused on the process, my process of preparation, and my process of testifying to do the best job I can, but realize I'm a bit player in a larger drama here. It's not my case to win or lose. The fate of the case or Western civilization does not rest upon my shoulders. But I'm going to do the best job I can, whether that helps, hurts, whether the trial is a win or a loss. I have no control over that. I'm going to move on one way or the other.
I got lambasted in court last week about it being emotionally involved with a defendant, not sexually, nothing inappropriate, but having emotional feelings about that person. The experts, the psychological experts on the other side, were what I call formulaic. They went in and did their job. It could have been they could be doing it to a lamppost. It didn't matter. There was no connection. Whereas I understood what this person went through. I did feel sorry. I did have an emotional investment. And in criminal, I think in criminal and civil work, you have to have an emotional investment. In death penalty work, they say you need to love your client. And I believe there's some truth in that. Because if you don't love your client, the jury is not going to love your client. But from an expert perspective, everything is not just science. And it's not just scientific articles or numbers or standard deviations. That person is a person, whether it's in a personal injury claim or in a criminal case. And somehow that uniqueness of that person has to be conveyed. And it's very difficult, at least for me, if not impossible, not to have some feelings of empathy for people, not to be able to imagine what it's like to have lived their lives. And I do think we have to have some care and concern, even from an insurance perspective. I had a case where there was a number of day schools here, preschools that were being sued, owned by one person because something happened at the daycare, which was probably out of the owner's sense of it's liability because they own it, but they didn't cause this to happen. And when you really look at that case, whether from a defense perspective, especially or a plaintiff perspective, these people who worked their whole lives to build this business are going to lose that business. And there's responsibility there to tell the truth. There's responsibility there to try to engage the judicial system to come out with a fair outcome, because these are people's lives. And most things that we deal with as experts do affect people, whether it's even through a business in one way or another.
Absolutely.
Yeah.
Before we wind up, I do want to address our post-trial or post-engagement practices. Sometimes expert witnesses only have their own one shining moment, their one day in court long before a case finishes. But is there anything that you do after a case to see whether or not it went to settlement, to see who won? Do you contact the attorney and ask how your performance was? What do you do after an engagement?
Good question. Most of the times, I don't know Mr. Quinley's experience, many attorneys, even if they get along well with you, they don't tell you what happens at the end. They don't call you up and say, hey, we got a good settlement, or this is what happened. You just never hear from them. Many times I'm curious and I'll call. And the reason I'm curious is I want to know if anything I did hurt or help the case. I want to learn from it. Obviously, I'm concerned and interested in what happened, but I'm also interested in how they think I did. And I don't mean for complimentary purposes necessarily. I want to know what a juror thought. I want to know what they felt. So yes, I think that follow-up is not only good for the relationship with the attorney, but in terms of, developing our own skills and understanding what works and what doesn't.
What form does that follow-up take?
I don't know if it matters. I guess my opinion, it depends. I've called people up, but people are busy. I've emailed people and said, if you get a minute, please call me.
I think you have to calibrate that to the communication style and the realization that these are very busy people. And
Yes.
I don't want to put them on the spot. And I think that a phone call is more likely to do that than an email where they can be reflective versus reactive. I do struggle with institutionalizing this as a discipline because it is so tempting to move on to the next case. What I try to do and recommend is a couple of things. Number one, don't quote ask for feedback. People feel challenged and on the spot to ask for feedback. But if you ask them for suggestions,
Mhm.
I know it's a small phrasing, but Daniel Pink has this whole thing. Don't ask for feedback. Ask people, how can I improve? After the case, what suggestions might you have for me to improve? Either my reports, my testimony at the deposition, my trial performance. I don't need an instant answer necessarily, but to pose those perhaps in written form and not to ask for feedback, but to ask them for that. People love to give suggestions,
Mhm.
but feedback has a whole different connotation. Number two, I think it's important to follow up to make sure that there have been no, again, Daubert type exclusionary motions that were filed and ruled on. I've had cases where I've gone on my merry way and I think got good vibes from retaining counsel. I found out months or years later that there was some judge's ruling who, as an aside, may have it's never because I'm not qualified, but because some opinion that I gave they considered to be a quote legal opinion, even though my reports say I'm not an attorney. I'm not giving legal advice, and I didn't agree that that happens to be a legal opinion, but that's part of your as your kid, it's part of your permanent record as an
Mhm.
expert. And I've been surprised in subsequent cases. Do you know that in the case of XYZ versus so and so in Colorado, the judge ruled, and because
No idea.
counsel hadn't told me, now I've learned to put in my engagement letter that they must inform me promptly of any Daubert type or exclusionary motion. Now, how you enforce that between you and me, that's the difficult thing. What's going to be your sanction? The case is long gone. The cow has escaped from the barn. Okay, the bell has been rung, but still to have that. So if nothing else, to for your peace of mind, or to be armed when it's thrown back in your face and your nose is shoved in it. And so I think it's important just to stay in touch, put it on recurring diary to check in with the firm or the attorney. If you've seen an article or if you've written an article as an ongoing part of your thought leadership, if you're publishing, I agree newsletters are probably overrated, but
Mhm.
if you continue to write, if you continue to speak, if you continue to read stuff, material that you can have an excuse to check in with counsel, put it on like a quarterly diary to check in and just to cultivate through repetition, like water on stone, top of mind awareness on the
Mhm.
part of the attorneys who are positioned to send you business.
Yeah, and always remember that they have all your transcripts from years and years ago, that they're all available, and that you will be quoted on that. And it's very difficult, to remember the names and facts of every case. But I was confronted from a case from 1990, let me think, 93 that I was on. So this is what 93 was, that 20 years ago, easily 20 years ago to 2000. I don't even know,
Like
more than
30.
that. 30 years. It was 30 years. It was no, it was no, no, it was 2000. Yeah, it was 93. Yes, it was 93. So 30 years ago, and they were yelling at me, why don't I remember the details? But I did remember the details. They handed me the Supreme Court decision, the state Supreme Court decision. I saw the name and I was able to describe the person. I knew how many people he had killed. I knew what county he was in. I didn't remember everything. I knew things like, what problems the mom had very generally. But they will ask you all kinds of things, and it's very difficult to be consistent in every answer that you give, every single answer, and they will pull all that stuff out. But I think what maybe we're talking about here is to have that relationship with an attorney, that they are listening and know how to confront that and have looked at your life enough and your work to be able to understand what you do.
And to get out
Yes,
ahead of that, I always try to cover before testimony with counsel. Look, I've written 700 plus articles
right.
over 3 or 4 decades, and I don't have photographic recall of them. And my views on certain things have probably evolved over the years. Just like a doctor who's been in practice for 40 years, is he or she going to see medicine the same way as they did fresh
No.
out of med school? Or an attorney practicing? It's a good thing for those views to evolve. I was in trial in Norfolk County, Massachusetts in the summer of 2017, and the opposing counsel quoted something that I had written in the 1980s. Okay.
Hmm.
So then that's fair game because when I was doing all of this writing, I had no grand design to be ever an
Hmm.
expert witness. Not that it would have changed things, but it was that kind of visibility that propelled me to a level of visibility where firms
Right.
and attorneys unsolicited started contacting me to serve as an expert witness, all of which is to say, look, I can't guarantee that they can't find something in that haystack of material to try to use to impeach me. That's where looking at the context of the article comes in, or the book, looking at the how long ago it was and whether your thinking has evolved and whether the circumstances, would apply in the current case. That's all fair game, as is former testimony, but I try to preempt that and say, look, they may dredge up some stuff. I can't say that they won't, but we'll just have to deal with it.
It has been an absolute informative and elucidating experience having this panel with both of you. Before we wrap up, do you have any last advice for expert witnesses, in particular newer expert witnesses or attorneys working with experts?
It's a very difficult area to break into because everybody wants to do it or believes that they can do it. I can't speak for, insurance issues and whatever, but obviously having a career prior to doing this is important. To jump into forensic work as a youth right out of school is very difficult to do. And I've testified against people that have 2 years out, 3 years out, and they do not have the breadth of experience. So my guess would be in my professional, my limited profession, is working somewhere first is very important. Whether it's in a prison setting or in a private practice, whatever that might be, it's very difficult to jump into. And I believe that my word of warning would be if you jump into this too early, you're going to make some serious mistakes. That it's a expert witness testimony is a responsibility. And it's a complex responsibility. And if you really want to get into it, I believe into mentoring. You could be mentored by someone. You could do parts of other people's cases. You can do part of their research. You can do a lot of different things. But if you think you're going to be a TV star at age, 27, that's probably not going to happen.
I totally agree. And it's sort of a chicken and egg situation because to get the experience, you got to get the case. And to get the case, people are looking for experience. But what I would say is technical mastery of your subject matter domain is not enough. Those are table stakes. To be effective, you need a blend of hard skills, that's where the technical expertise comes in, and soft skills in terms of communication, diplomacy, and emotional intelligence. Let me put it this way. There are people who I think have vastly greater knowledge of insurance and
Hmm.
insurance claims than me, but they are not cut out. Maybe they dipped their toes in that water at one time, but they have no appetite for the rough and tumble of the litigation system, the adversarial system. You've got to have a thick skin because you're working with very smart people. That's a non-financial benefit of the job. The flip side is you've got extremely smart people on the other side who are preparing for weeks to make you look uninformed, inconsistent, and incompetent. And not everyone has the appetite or tolerance for that. And so the table stakes are having the credentials, having the years of experience, maybe a few gray hairs, that the publishing, the speaking, the chops, the bona fides, the availability, but to know that this is a very stylized kind of writing. It's a certain performance art when it comes to testifying, and that, if you've got a big ego or if you're thin-skinned and can't work under stress, can't work under deadline, can't work with sometimes some very quirky people, you know, but they're paying your bills. You got to have a tolerance for all of that. That maybe is where the emotional quotient, the
Hmm.
EQ, comes in.
Absolutely agree with that. And I think you state that incredibly articulately
Thank
because this is not a regular job and it's not regular demands. And it stresses your moral life, your cognitive life, your emotional life, your personal life, your time. This is not just being famous and getting up on the stand. It's serious. And I think that all the things we talked about today about the relationships, I mean, Noah started this off talking about relationships. It is a relationship based. It's also a relationship with a jury. I mean, we haven't talked about that, but it's all the bottom line is that you have to be able to establish a relationship with a jury. You have to know how to communicate in a way that other people can understand, and that's the emotional skills. Because a lot of people get up on there with technical slides and all kinds of numbers and standard deviations and Lord knows what. And what they really want to know is this was unfair. Here's the 6 reasons why. So, we have to really think about our audience as well. Our audience are lawyers and everybody else. Thank you, Noah.
Absolutely. Dr. Brahms, Mr. Quinley, thank you so much for joining me today for today's panel.
Thank you very much.
Thank you all.
As always, thank you to our listeners for joining us for another episode of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.